And a very good morning to you. This is John Fradgley from the Bell Legal Group, back with you for another program of The Law and You. As always, your opportunity to get free legal advice between now and 9:30. That's, of course, 10:30 Tweed Coast time. All we need you to do is get on that telephone as soon as we possibly can. Our number, of course, 55208888. That number 55208888. If you need to get through to us on email, don't forget, of course, talkback at 4crb.com. That's it. 4CRB, or talkback at 4crb.com. So you can possibly try that number and see how we go there. Thank you to all the people who called through last week and made for such an interesting program. Certainly was a big one. We had quite a number of calls. In fact, I think there were around about 7 calls, including a couple that I took off air. So all well and good. So thank you to all of those people who called through and made for such an interesting program. And it looks like today is going to be no exception, starting exactly the same way as it did last week. As we say, a very good morning to Clara. Hello, Clara. How are you today?
Good, thank you.
Clara, are you there?
Yes.
Hello?
Yes, can you hear me?
Yes, I can hear you now, Clara. Sorry. Just having a little bit of trouble with the headphones at the moment.
Okay, yeah.
So hopefully we've got that problem cured. How can I help you today?
Yes, I did make a power of attorney for my daughter some years back. But I wouldn't mind to add my granddaughter as well, because that time she's too young, too young for it.
Yep.
Is that possible? Do you just add it too, or you have to make a new one?
Unfortunately, you've got to make a new power of attorney, Clara.
Oh, shoot. Yeah. Why? You get a second person in?
Yes. Because there is no provision under the legislation for someone to simply be added to a power of attorney. So what you've got to do is do a new one. How long ago did you make the old power of attorney?
It must have been maybe around 2000 something.
Right, okay, so it was under the new legislation. Yes, look, unfortunately, there's no other fix to it other than to make a new document. So that's the course of action that you're going to need to follow if you want to get that sorted out.
That's a bit of a bummer, isn't it?
Yes. Oh well, it's just the way the system works.
And how much would it cost in a moment?
Well, if you're going to go to a lawyer and get it done, I think that you'd be looking at probably around about $250.
Wow. And is there somebody else who can do it?
You could possibly go to the public trustee and see whether they can do it for you. That might be another option for you. All right, then.
Okay, thank you.
Okay, Clara.
Bye.
All the very best. Time on 4CRB is just coming up to 9 minutes past 9. This is The Law and You here on 4CRB. Your opportunity to get free legal advice. All we need you to do is call that telephone number, 55208888. Don't forget, if you live south of the Tweed River, you do need to put 07 in front of the number. And we say a very good morning to John. G'day, John. How are you today?
I'm good, John, and you?
Very well indeed. Thanks. How can we help?
I just had a question regarding defamation laws.
Yes.
Particularly online defamation laws. There was a situation recently where we posted some negative feedback on a publicly listed company that, on an internet forum, and I've heard rumours that they're looking at taking a defamation case against some of those people who've made those comments online. I was just wondering what you should do if, in fact, you do receive a defamation notice, and what their sort of play might be, what the corporation generally might have in mind.
Yes, I'm not sure that a publicly listed company can actually take action for defamation unless it's criminal defamation. So, so the law is a little bit different in relation to defamation. What I could do in relation for you is take a little bit of a look at that, and I could make some more comment on it next week if you like.
Yeah, sure. So that'd be good.
Yeah, but my immediate reaction is that unless it's criminal defamation, I don't think that a publicly listed company is able to take action for defamation.
Right. I'd heard that they could through the Hot Copper Forum, which is the online forum.
Right. Okay. Yes.
Well, cases where
Well, they may have been criminal defamation cases. So, look, I'll have a look at that, John, and I'll certainly make a comment on it next week. That'd be the best idea.
All right. Thanks, John.
Okay, all the very best. Time on 4CRB is just coming up to 11 minutes past 10 on the Tweed. The Law and You is the program. 55208888 is the number if you have a question or a query. That number again, 55208888. Please don't leave those calls to the last 5 or 10 minutes of the program. Last week we had a flood of calls right through, but we did have a couple of calls that arrived just a little bit too late to be taken on air, so we had to take those off air. So we'd prefer to avoid that if we possibly can. 55208888. There's presently no one online, so if you have a question or a query, you could call now and get straight through. While we're waiting for some calls to come through, there have been a few things that I've been trying to talk about for a few weeks, actually, but the calls coming in have not permitted me to do so. One related to a warning which was issued recently about the increasing fraudulent activity in relation to land transfers, and basically setting out that property fraud is on the rise. Now, this follows a call that I had from someone quite some weeks ago in relation to this, expressing concern at the Queensland Government's decision to abolish paper titles come the 1st of October 2019. So I'll have a little bit more to say about that in a moment, but first of all, we'll say good morning to Malcolm. Hello, Malcolm. How are you today?
Good, thanks, John.
How can we help?
I wanted to make some inquiries about power of attorney for a company.
Sure.
Okay, I needed to do some research into a company of which my mother was a director of.
Yep.
I'm the power of attorney for my mother.
Right.
Okay. What's been told to me by the bank, when I first spoke with them, they said that we have records going back to eternity, regardless of the 7-year rule. That's what they said originally, but I needed to find some information with regards to my mother's company, and they said that they told me they can't release the information because I'm not the power of attorney for the company.
Yes, no, that's right, because the mere fact that you're your mother's power of attorney doesn't mean that it gives you the right to act in her stead as a director of the company. The appointment of a director to the company is an appointment by the company, and you would need to have a power of attorney from the company saying that you're appointed as an attorney on behalf of the company.
Right. Now the company has since been closed, John.
Right, okay.
That's point number one. Point number two is I don't believe that there's any evidence that there was indeed a power of attorney for the company.
Yeah, well, if there was no power of attorney for the company, then in the first instance you don't have any right to seek that information. But is your mother still alive?
Yes.
Okay, and is she still competent?
No.
Okay. All right. So, well, as her power of attorney, was she also a shareholder of the company?
Yes.
Okay, well, as power of attorney for your mother in her capacity as a shareholder of the company, you should be entitled to seek that information from the bank. So it may be a case of just going back to them and saying, look, in your capacity as attorney for your mother, as a shareholder of the company, that you're seeking this information.
Very good. Just one other question too.
Sure.
With regards to power of attorney, what are the consequences for somebody that would be breaching the rules of the power of attorney? Like, for example, taking liberties for which they're not entitled.
Well, unless the power of attorney permits conflict transactions, then persons who are doing things that are contrary to the best interests of the donor of the power of attorney certainly can face sanction for that under the provisions of the Powers of Attorney Act. There's quite serious consequences for that if someone's abusing their situation.
Right, very good. Thanks very much, John.
Okay, Malcolm, all the very best.
Have a good day. Bye-bye.
And the time on 4CRB is just coming up to 15.5 minutes past 10 on the Tweed, as we say a very good morning to Peter. G'day, Peter. How are you today? Peter, are you there?
Yes.
Hi, how are you? I'm well, and you?
Yeah. Good show. Nice show.
Thank you.
Yes, I'm well, thank you.
How can I help?
it's something I'm not over concerned with. I listen to your show all the time, and I thought maybe I should call in, just for a curiosity, kill the cat. My sister died, just recently, and, she was a large property owner. I got 10 properties when my father died. She got something like 85.
Mm-hmm.
All the properties when she died were the properties she inherited.
Mm-hmm.
She never married, never had a boyfriend, lived a spinster life, just a workaholic.
Mm-hmm.
We never spoke for 40 years.
Mm-hmm.
And also my youngest brother. But the other brother did, so there's 3 of us. And, so what's happened was, in the will, she left, her entire estate, to, my adopted brother and my blood brother.
Right.
I never got a mention, of course, and I never expected to, because I was the evil person who threatened to contest the estate when my father died in 1968.
Right.
So, all I want to know is, do I have any claim against the estate? And also, a distant cousin of mine, she also left a large amount of shares to, like BHP and da-da-da-da. So my sister was very wealthy, okay?
Mm-hmm.
So, do I have any claim as the blood brother, or does that make no difference, or
unfortunately,
because she left to the other 2 and she didn't leave to me, or not?
Unfortunately, not, Peter. A sibling does not come within the class of persons who is entitled to make a claim on the estate of a sibling, unless they were financially dependent upon them at the time of their passing. Where did your sister live, in Queensland or New South Wales?
Yeah, I know it's different, isn't it? Yeah, Queensland. And
Queensland.
I know New South Wales is totally different.
Yeah, well, New South Wales, there might have been a remote chance that you'd have a better chance, but certainly in Queensland, as the brother of your deceased sister, your only grounds would be if you could somehow knock her will out on the grounds that she was not competent when she made it, or she was under duress or something like that, but that's probably a pretty long bow.
Well, she had Alzheimer's.
Well,
and when she made it in 2000, she was still competent. So I don't want to go down that road and try to tell any lies. She was. What really happened, actually, just in a nutshell, is I have 3 daughters.
Yep.
And she left her entire estate except for 2 properties to my 3 daughters.
Who did?
Okay, which I'm very happy about. Which I think is
your sister has left her entire estate to your 3 daughters.
Yep, left the entire estate except for 2 properties.
Mm-hmm.
And the 2 properties she left was to my younger brother and my adopted brother.
Yep.
And where I'm a bit annoyed, why I was wondering whether I had any claim was, it's more, I guess it's a bit vindictive. But what it was, because I don't speak to them anyhow, what it was, her estate was controlled by public trustees.
Yep.
So what happened was, when the will was done, I got in contact with the public trustees, and the particular woman that took the details of the will, she took it, it was written on a piece of paper by my sister, and dropped off by my 2 brothers. She was dropped off at the public, and they sat outside. And at that time, she wasn't. She was pretty far down the road with Alzheimer's. So what I'm getting at is, I know this also would jeopardise my daughters, because she wrote in favour of them. I understand all that.
Yep.
But what I think that my 2 brothers anyhow committed fraud. But that's another story. Because the story was that she was my auntie was, or my distant auntie, should I say, my second auntie, whatever you want to call her, was saying that she had her over for dinner. This is when she was still calm, and said, "Well, I'm leaving. My brother Peter, that's me. I wouldn't give him a cent for trying to contest the estate, but I'm going to leave everything to the 3 girls." And not that it matters about 2 houses when they got something over 60 property. It doesn't really matter. But what really annoyed me would be to think that they committed fraud in the sense of even if it was disadvantage to my daughters, I still think what they did was illegal.
Yeah, well, the problem you'd have, of course, Peter, is proving all of that in a court of law. And as you rightly point out, if you contest the will and the will is found to be invalid, then it would go back to any previous will she made before that. So you've got to go back and look at all of the previous wills, because an earlier will may be less beneficial to your family than the current will. So
my daughters weren't in it. We know that already.
Well, but you need to know what what was in the previous will, whether you were in it. So if you weren't in it, it's less beneficial.
I was never in
And
it.
the other
No, I
thing,
was
of
never
course, is that there is a big proof issue that you would need to satisfy in saying that your sister was there was undue influence exerted on your sister in making the will. But that's the only basis upon which you might be able to set the will aside. But we'll have to leave it there, Peter. Unfortunately, we've got a couple
Can I
of
ask
other
just
calls.
one last question, one real quick question?
Yes.
Very quick question. My 3 daughters decided to look in with the lawyer for the trustee at the time, about a month or so ago, decided to have a look at all the bank accounts, and they saw an enormous amount of money come out. Before she died, there was an enormous amount of money came out of her bank accounts where checks were written to the 2 brothers.
Well, that would have to be looked into by the executor, and you said that's the public trustee?
That's right.
So they'll need to look into that. So your sisters, although money in the bank is irrelevant to your daughters, isn't it? Because they've been left property. Yeah. So
No, they got left it. No, they got left their bank accounts.
Oh, did they? All right. Well, if that's the case,
everything.
then the public trustee should be looking into why that money was withdrawn to be satisfied that there was no either undue influence, duress or fraud involved in that. All right then?
Well, thank you. Thank you very much.
Okay,
You have a
Peter.
nice day.
You too. All the best. And time just coming up to 22 minutes past 9 past 10 on the Tweed. As we say, a very good morning to Bill. G'day, Bill. How are you?
Good, thanks, John.
That's good. Sorry to keep you waiting so long there.
That's fine.
How can we help?
In 1986, a property was built, low level, and 10 years later, to the rear of that, was added a duplex.
Mm-hmm.
The garage for the duplex...
10 years later.
10 years later.
Mm-hmm.
The garage for the duplex had been the garage for the original property.
Mm-hmm.
It would seem that both properties are slightly over either boundaries.
Mm-hmm.
How can that be now addressed? Has got to get some special dispensation from the council?
When you say it's over the boundary, do you mean it's over the property boundary? Or is it too close to the setback? Is it within the legal setback?
Both properties are within the overall extremity, but the way it was then divided for Unit 1 and Unit 2, it would appear the garage for Unit 1, which was a new garage, is slightly into the area for Unit 2.
So when you say it's a duplex, what you're actually meaning is that it's been strata titled? Or group titles, so there's separate titles for the 2 blocks?
Separate titles, yes.
Okay, well, what you've probably got to do, Bill, is you'll need to get a surveyor to have a look at it and to work out where exactly or what exactly the error is, and there will probably need to be a boundary realignment between the 2 properties to fix the encroachment.
Right.
Because it sounds like one property is encroaching onto the other, and are the 2 properties still in the same titles, the same name, so does the same person still own them?
No, 2 different people.
So there may also be some compensation payable to the owner whose property has been encroached upon as well.
Right.
But the first step would be to speak to, are you one of the owners?
No, I'm a power of attorney for the owner of Unit 2.
All right, well...
Which was the addition.
Right, well, the first thing to do would be to speak to the adjoining owner and just let them know what you think has happened, because the 2 lots together should engage a surveyor to work out whether there has in fact been an encroachment onto the boundary or over the boundary of one of the properties by the other. And then it then needs to be surveyed to say what the extent of that is, and the surveyor would also be able to assist in how the error in the current existing error in the boundaries, the encroachment, can be dealt with. And then, I mean, for example, if it's a few inches and it's over half of the block, it may end up being a very small piece of land, and the owner of the adjoining property might say, well, look, I don't really want any compensation because what I've got is what I thought I owned anyway, so it's no big deal. But unfortunately, it's one of those things that does need to be sorted out with the owner of the adjoining property as well.
Yeah, the encroachment might be as much as 600.
Right, okay, so there could be a little bit involved, but the steps that I've given you, the first thing I would be doing, Bill, is speak to the adjoining owner, agree on a surveyor that you can get, and if you can look back on the plan from when the group title was originally done, see who the surveyor was who drew that plan. If they're still in business, they'd be the obvious ones to get to do it, because it may be that it was a surveying error, which means that the surveyor should be fixing it without cost.
Yes. Yeah, understand that. Thanks very much, John.
Okay then, Bill, all the very best. Time on 4CRB is just past 26 minutes past 9. That's, of course, 26 minutes past 10 on the Tweed. Probably time for one more call, as long as it was quick and you get on that telephone straight away. But while we're waiting for that, just going back to what I was talking about a little bit earlier about the increasing fraudulent activity in land transfers, and basically how this is happening. The person who's at the biggest risk, you might think that the owner of the property is the one who is at the biggest risk, but actually they're not. The person who's at the biggest risk is anyone who purchases a property that has been basically hijacked. So where a fraudster pretends to be the owner of a property and sells it to a prospective purchaser, it's basically known as property hijack. And the fraudster will convince their own solicitor that they're the true owner of the property, and then the transaction proceeds. Now, when the fraud is discovered, for example, the true owner of the property finds that their property's been sold to someone else, because it's a fraudulent transaction, they can in fact have the transaction undone. But the problem is, of course, that if the buyer has borrowed money to purchase the property and they've given a mortgage over the property, the lender is left without security, and the purchaser remains liable to make the payments on that debt. So it is quite a serious issue. There have been a couple of instances where this has been picked up right at the 11th hour in the last year or so. So it is a big issue. The properties that are most vulnerable to fraud are properties with absentee owners, properties where the owner's elderly and perhaps in a nursing home, high value properties, and of course properties that are mortgage free. So occasionally the process might be discovered, or the fraud might be discovered during the sale process, or the titles office might even realise it's a fraud and refuse to register the documents. That's also a possibility of what might occur. But the big thing that is happening now, which will hopefully minimise the likelihood of any of these property fraud transactions occurring, is the stringent procedures that are now in place requiring everyone involved in the sale process to be identified. And there's now comprehensive identity checks that must be carried out by authorised agents to verify the identity of the parties to the transaction. So whilst it will certainly continue to happen, and when it does, prompt action is necessary, because obviously if you discover in a transaction that there is a fraud, it's far better that it be discovered before the transaction's completed and the fraudster has been able to make off with the money, because that would obviously be the ultimate protection for the buyer, who's the one who's likely to lose out. Nonetheless, it does pay to be vigilant in relation to these things, and just to be aware that that when you're buying a property, it is particularly important to make sure that those identity checks, etc., are all completed in relation to the person that you're buying the property off. Because once the money is transferred out of the country, of course, it becomes extremely difficult to get it back. I'm John Fradgley from the Bell Legal Group. It's been great to be with you today for another program of The Law and You. I'll look forward to being back with you again next week. But as always, until then, it's goodbye and God bless.